All rise. Division 2 of the Court of Appeals of the State of Washington is now in session. Commissioner Aurora Burse is presiding. Our first case on the July 9th, 2025 docket is a motion for discretionary review, case number 60222-9, Dawn Allison v. Christine Allison.
Thank you. Please be seated. I am ready to hear argument on our first motion for discretionary review. And it looks like there's been 3 minutes reserved for rebuttal.
Yes. Good morning, Your Honor. That's correct. Good morning, Your Honor, counsel. May it please the court. My name is Beverly Allen. I represent Christine Allison, the petitioner. And this motion for discretionary review seeks overturning the trial court's denial of our 12B6 motion to dismiss. And Your Honor, my argument today will be distilled into 2 arguments, 4 cases, and 2 statutes.
Way to keep it simple.
So regarding the first argument, you'll be hearing that there was a fatal deficiency and that the statute requires the consent of a legal parent as a threshold issue to even proceed to a contested hearing on a de facto adoption. The second argument turns on the adoption statute, which severs not only prospective parental claims, but even existing parental claims. The 4 cases that I would like the court to focus on, and I will direct the court's attention to in my arguments in order, are AFJ, which is 179 Washington 2nd, 179.
You don't have to read me the sites.
Okay. JDW, RLM, and CJJI, and yes, those cases are cited in my table of authorities.
But we're leaving CROF out?
I planned to address that in rebuttal, Your Honor. I imagine that...
It's your argument, Counselor. Go ahead.
Yes, Your Honor. And then the 2 statutes, of course, I'd like the court to focus on are 26.26a.440 and 26.33.260. So I'll dive into the cases first. AFJ was a case where the court was wrestling with the issue of can foster parents even file de facto adoptions? This was a hotly contested issue, and in fact, the state of Washington was invited to provide amicus briefing, and they did in fact provide amicus briefing. I've attached that as an exhibit to my motion. And the ultimate conclusion was yes, a former foster parent can in fact maintain a de facto petition. However, that itself turned on the consent of a legal parent.
Well, foster parent status is not a bar, I think.
Correct.
To acknowledge that post AFJ. And really sort of drilling down, we're getting into the specifics of this Superior Court's decision that apparently the department can stand in as the legal parent and provide the consent. Am I distilling the issue here?
Your Honor, that is one issue.
Okay.
I did cite to, and I quoted the trial court that they did say that the state of Washington can act in local parentis, in other words, to foster that or meet that element, but that wasn't heavily discussed in the trial court's oral ruling. The bulk of the trial court's oral ruling, and indeed the response, focused on what I would call the equities of the situation,
okay.
the hard facts. So in fact, that question, though, although that wasn't the turning point, because in AFJ, and in fact, in all of the cases that I could find that were published and discussed de facto parentage, there was, in fact, a legal parent that consented to each and every one of those scenarios, including AFJ.
I was going to ask you, and I was also going to ask opposing counsel, if anybody has located a case where the department is the sole consenter, if that's a word, to fostering a parent-like relationship.
No, I could not, despite all my diligent efforts. I did find some discussion of local parentis in several cases, and I will briefly touch on CROF. In CROF...
Well, I mean, in the response, respondents actually rely heavily on a paragraph in AFJ that talks about that. I'm not sure I read it the same way that they do, but...
I don't read it the same way that the respondent does either. I do note that there was some discussion over the placement and the relationship, but AFJ also addressed the state's concerns. Again, this is the department saying we don't have the authority. And they acknowledged that the key factor here, that the constitutional guardrail, in other words, was to protect the constitutional rights of the parent by requiring that as a threshold issue. This came up before the court some years later in JDW. In JDW, that was a case where the mother essentially objected to the prospective de facto parents' parenting abilities. And I would acknowledge that there were sections of my motion to dismiss that touched on that, but as the court might see from my oral argument and in my briefing, that's not the focus. I will concede that JDW essentially said you don't actually have to meet every single element or flesh it out to the satisfaction of a trier of fact at the complaint level, that a sworn pleading there is enough. However, there are two threshold elements that the court did preserve and did discuss in JDW. One of them was, again, the consent of the legal parent, because dating back to Troxel and beyond, we have this constitutionally recognized guardrail for parents, and we require that consent. RLM, I think, highlights the adoption piece of this. So again, the first petition for de facto parentage was after the finalization of the adoption of the child by Ms. Allison. Mr. Allison was not a party, they were not married at the time, and the RCW statute, RCW 26.33.260, is clear. Not only does the decree of adoption divest any parent of all legal rights and obligations in respect to the obligee, it also terminates existing parental rights. That was the case in RLM, where you had a birth mother whose rights were terminated, tried to intervene and stop the adoption, and the court said she could not do so. So again, these cases sometimes involve very difficult facts, but I don't think the court can ignore the actual statutory requirements. And as the respondent conceded, CR 12b6 is proper when the plaintiff is asserting a cause of action not recognized in the state. We don't recognize the state of Washington being able to act in loco parentis to give consent for a claimed parental relationship. Even the state does not recognize that authority. So with that, I'm almost at time unless the court has an additional question.
No, thank you.
Thank you.
Good morning, Your Honor. Janice Lincoln on behalf of Dawn Allison, present in the court. May it please the court. On May 28th, Mr. Allison filed his de facto petition. Then on October 29, 2024, the Honorable Judge Amamello of Thurston County Superior Court properly denied Ms. Allison's CR 12b6 motion to dismiss his petition. I'm gonna, I guess, look at it a bit differently and do a different roadmap following the 2.3b reasons for a discretionary review. So starting with the probable error statute,
I'm familiar with this.
Okay, so it's a two-pronged test in that the Superior Court has to have a probable error and there needs to be a fact. And I cited the Howland case as a reason, like she was a woman in our mental institution asking for community release, and the appellate court that was denied at this level, the trial level.
I thought that we were considering this motion under B3. Was there also a B2?
So I'll speak to that. So in their motion to dismiss my motion to dismiss, or their response to it, they brought up B1 and 2, and so I didn't want to not argue those. So if Your Honor would like me to just do the departure argument, the B3, I'm happy to do that.
I think let's focus on that.
Okay, that makes it quite easier. So in the dependency of CJJI, the petitioner must show not only simply that the lower court deviated from practice, but it also to such a great extent that it requires review or revision, and that's not the case here. And we agree with the petitioner that that rule is both substantive and procedural in judicial proceedings. So in Croft, CR Independency of Croft, I'll just shorthand it, they are unable to raise case law, actually, that where the Superior Court, Superior Court was overturned on appeal because they brought in a case law that wasn't argued by the parties, and they hinged part of their argument on that, saying that's what the error was by Judge Amamillo. But in fact, we always hear about in rulings that Superior Courts bring in precedent and others to make their ruling. That is not outside the usual and normal practice of judicial proceedings. So I would say that Prof is not an error by Judge Amamillo. So then second, AFJ, they rely heavily on the department's brief in that case. And actually the Supreme Court, and I went back and listened to these oral arguments, the Supreme Court asked both Legal Voice and DSHS to provide amici, and they did.
I think I'm less concerned about the briefing and more concerned about the opinion.
Right, okay, so.
And I'm going to ask you the same question that
Sure.
I asked the opposing counsel. Is there any opinion out there that said the department can be the sole, again, I may be mangling the language, consenter to a parent-like relationship to provide potential DFP status?
So in Prof, for instance, the mother sadly died in a fire, not able to consent, died with one of CRF's siblings. The father had the child for a short time, but in dependency too, he abandoned. And so the Court of Appeals actually said, yes, the department can stand in loco
But there is
parentis.
at least an allegation that while the mother was around, she had consented to an aunt having a parent-like relationship. And again, an allegation, I know we're at the
Right.
dismissal stage.
Well, they all lived together, and so that was
Okay.
the idea.
So there were facts there.
There were some facts
Potential
there,
facts. Okay.
potential facts, but ultimately what led to the de facto, after the Aunt Miss Smith tried to intervene, the department denied her intervention, then they denied her de facto, and on appeal overturned the lower court's decision and allowed Miss Smith to become the de facto parent of the child.
Okay. But again, there are different, this is not a sole department consent situation.
Well, but in AFJ and other case that's not coming to mind, there is not a bar of using the time that a child was in foster care as a bar to create part of the consent portion of or in loco parentis in the full time frame of a child's life, that you can count that time, and I believe that's AFJ. And in this case, Mr. Allison parented this child for 3 of her 6 years before filing this de facto. That's 50% of this child's time, as well as having a sibling of this child in his home that he's currently full-time parenting. So I think the facts are different, and I think the conclusion that AFJ reaches that that we leave it in the able hands of trial judges to determine whether in each case the elements have been met without imposing ratification limitations on the scope of judges' reviews. So I think that this case is so fact-specific because I didn't find other cases where we were talking about sibling placements and the best interest of the child. In JDW, it was a best interest argument that that the court should weigh the two, both the de facto parent and the biological or natural parent's rights versus the child's, and that should be decided by the trial court at that point. And so in our case, we're asking the same. The 12B6 is an unusual remedy when there's just no claim that the petitioner can proceed on. And in this case, they cite the adoption statute, but the adoption statute divests all legal parents, and alleged parents actually. But if you look at 26A.010 in the definitions of what parents are in our state, alleged parent is different than a de facto parent. They have different rights in our state. So he hasn't been adjudicated as a legal parent, an alleged parent, or a de facto, and that's why we're asking that this be sent back down so that he can be adjudicated or not adjudicated as the de facto. So I think that
So you're saying, and I'm just going to throw out a hypothetical, ignore the foster status for the moment. Let's say we have a child who was in a bad situation, maybe the mom left the kid with the aunt for a while, but eventually the mom decides to place their child up for adoption. They place them up for an adoption. Some couple across the state adopts the lovely child. You're saying that the aunt, even post-adoption, can then come in and say, listen, I'm also a parent too?
I think it depends on the time. We look back to LB, and the court has looked at the full amount of time. If this aunt only had the child for 9 months of her 7 years, no, likely not. It turns on.
No, the aunt was involved from birth to the adoption. And then the adoption goes through. The aunt still has rights.
The aunt would have had to attempt to intervene in the adoption and file her de facto petition prior to the adoption being finalized. Okay. And that's what happened in Croft. Okay. That's what happened here. We filed an attempt to intervene prior to the adoption. And as soon as I couldn't get a hearing on the intervention, found out the child was adopted, we filed de facto.
Okay.
And so, yes, there has to be the safeguards, the due process prior to the adoption. Same, forget about an aunt. If it was an alleged father, same thing. Unfortunately, his rights would be divested if he didn't intervene prior to the adoption. But we did try to intervene prior to the adoption. So our case is distinguished. Also, I refer to it as the consent part of the statute, the 26A 4404F, which is a parent-like relationship consented. And Mr. Allison and Miss Allison raised this child as their own with her sibling, and I ask that this court find that the lower court properly denied the 12B6 motion. There is reason to send this to full adjudication, and I ask the court to deny the motion for discretionary review, lift the stay, and allow Mr. Allison's petition for de facto to proceed. Thank you.
Thank you so much.
Your Honor, I'll be focusing on 3 cases in my rebuttal. First, as to the arguments for discretionary review, CJJI.
I'm really familiar with the standards, so I'd rather hear the merits.
Sure. Regarding the Croft discussion and the court's hypothetical. So first of all, Croft, the factual statement, I'd like to correct that by my colleague here. On page 13, I cite to the specific section of the opinion. What happened was the mother in the Croft case was living in a separate residence at the time that the child first came to the department's attention. So the child was living with the mother's twin sister and her grandma. Then there was a fire and the mother died. So we know that at least the mother knew about and consented.
There were alleged facts.
I'm sorry?
There were alleged facts in the Croft situation where the parent could potentially have been seen to have consented.
In that case, nobody alleged that the department was the sole person to consent, Your Honor. So yes, there were alleged facts that the mother consented, and that is where under the JDW statute, which clarified AFJ, that is a threshold piece. That and the parenting functions. Parenting functions is a bit harder. If Mr. Allison had said, oh, I was never around whatsoever, never involved, then we would have a second threshold issue. As it is, when he fails to plead in his moving papers that there was a legal parent to consent, and when he fails to address the impact of the adoption in severing prospective relationships, all prospective relationships, that argument fails. Speaking of which, in Croft, which cites to Hansen, that's where you have the timing of all of this. That's where you have the due process piece of all of this. So in Hansen, or in Croft, and citing to Hansen, the court wanted to make clear that prospective parents have a right to have their claims adjudicated. Hansen was a 1979 case, I believe, well before LB, well before the de facto parentage statute. And so that wasn't even contemplated at that time. There was some discussion of in loco parentis and some discussion of, I think, the precursor to LB, which is that you have the right to have your claims heard. But again, that's been clarified, that's been codified. One would assume that the legislature, in making its choices to require the consent of a legal parent, chose to disallow non-parents to consent, even the state. And as I said before, the state itself in AFJ wanted the court to restrict its findings regarding foster parents. The court did that by insisting on citing to LB. And then again, JDW does not involve a local parentis claim, but it does make it clear that that is one of the required elements, threshold elements, to allow a full hearing. And so here we have a case where that threshold element is not met, and the motion should be granted. Thank you.
Thank you very much. I'd like to thank counsel for their briefing and their argument today on what I'm sure is a wrenching matter for both parties here. I do appreciate hearing both sides and being able to ask questions. I'm going to take this matter under consideration. I'm going to issue a ruling as quickly as I can because it does involve the potential placement of a child. Do either of you have questions before we move to our next case? Thank you very much.